All right, group four, Sam and Jessica again. We were assigned chapter 9, discrimination in employment. So according to Title VII of the Civil Rights Act of 1964, which is one of the most extensive federal employment laws, discrimination, it shall be unlawful employment practice for any employee, let me move this real quick, to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms of conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Basically just you can't hire or fire anybody because of their race, color, religion, sex, or national origin. The Supreme Court developed a three-step procedure for Title VII challenges. People claiming discrimination have about 180 days to file their complaint. And then there's a three-step process that follows. So step one is the plaintiff carries the initial burden of establishing a prima facie case of employment discrimination. That just means accepted as correct until proven otherwise. The burden then shifts to the defendant to refute the prima facie case by demonstrating that a legitimate, non-discriminatory purpose forms the basis for its actions. Just provide legitimate reason for their action, which is in non-discriminatory terms. And then the third step is if the defendant is successful in its contention, then the burden shifts back to the plaintiff to show that the defendant's actions were a mere pretext for discrimination. And obviously, if the defendant can demonstrate the absence of discrimination, then there is no need for the third step at all.
Well, the next section was on sexual discrimination. It's basically discrimination based on sex is also covered under Title IX of the Education Amendments Act of 1972. It prohibits sexual discrimination by public and private educational institutions receiving federal funds. And it does note in the book that it is the entire school or institute, even if only a portion of the institute is receiving the federal funds, the whole institute is still held to that. Title IX is administered by the Office for Civil Rights of the Department of Education. Title IX, like Title VII, makes a provision for sexual distinctions in employment where sex is an actual occupational qualification. So that would not be you would not be going against Title IX if that is actually a qualification of the job.
The Rehabilitation Act of 1973 and the Americans with Disabilities Act of 1990. The Americans with Disabilities Act, or the ADA, in conjunction with IDEA, protects individuals with disabilities against discrimination and assures equal access and opportunity. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination against any otherwise qualified person who has a disability with respect to employment, training, compensation, promotion, fringe benefits, and terms and conditions of employment. So it's essentially stating that you cannot exclude a person from a job or program simply for just having a disability. The ADA is similar to Section 504 and not only protects students with disabilities, but any person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded by others as having such impairment. Major life activities, as interpreted by the Act, may include such tasks as caring for oneself, performing manual tasks, hearing, seeing, speaking, breathing, walking, learning, and working. Also, it includes any major bodily function. And then Section 504 extends beyond the school environment and covers all people who are disabled in any federally funded program.
So qualifications for employment. Any individual with a disability is qualified under ADA if, with or without reasonable accommodations, he or she can perform the core functions of the employment position held or desired to be held.
Scope and protection, Section 504 and ADA. Both the ADA and the Rehabilitation Act impact public schools by prohibiting disability-based discrimination. When there is an allegation brought against school districts claiming discrimination, individuals bringing these charges may file a complaint with the Department of Education, and the Department of Education can terminate their federal funding if the complaint process passes the judicial process.
So racial discrimination, the equal protection standards prohibited discrimination, which can be linked with a racially motivated objective. Unlike Title VII, no remedial action was attached to the Equal Protection Clause unless there was clear evidence that segregation was caused by de jure, official, and deliberate laws or policies to promote segregation. And in the book, they talk about quite a few cases where this is the case. And it kind of, I guess the biggest one was actually not in education that they mentioned, or most compelling, I should say, maybe not biggest. It was against a power company. So not in a public setting at all, not only public school, or not, excuse me, not in a public school setting at all. And evidence revealed that they actually did not meet, or excuse me, that basically they held with the company that they were, excuse me, it did not hold with the company, excuse me, I misspoke there. It said they were in direct conflict with the provisions of Title VII in that case. Title VII involves two basic types of claims, disparate treatment and disparate impact. The Supreme Court addressed these two important issues in a later case involving discrimination on disparate treatment and disparate impact. So I guess basically not necessarily both need to be the case. It can be for one or the other. Disparate treatment simply means that an employer treats some people more unfavorably than others regarding employment, job promotion, or employment conditions based on race, color, religion, sex, or national origin. Disparate impact is merely a showing that numbers of people of a similar class are affected adversely by a particular employment practice, which appears neutral, such as a requirement that all employees pass a test. So even if it's not intended to be racially discriminatory, it can still be proven that the impact does in fact have a racially discriminatory pattern, even if it wasn't intended.
Apologize for going too early.
Oh, that's okay.
Age discrimination. Age discrimination in public schools primarily affects the teachers. In past years, many districts used to force teachers to retire when they reached a specific age. These policies and practices were challenged by teachers under equal protection guarantees. And according to the book, it was challenged with mixed reviews. Some people agreed, some people didn't. However, all challenges and uncertainties became insignificant with the passage of the Age Discrimination and Employment Act of 1967, ADEA, as amended in 1978, where any employee above the age of 40 cannot be discriminated against based off of their age. Amendments added in 1986 removed the limit completely, except for persons in certain public safety positions like firefighters or police officers. And the act covers teachers and other public employees. And litigation for age discrimination is very similar to that of race or gender. It's pretty much the same process.
So pregnancy and public school employment. Teachers in public schools are protected by the Pregnancy Discrimination Act of 1978. This law was an amendment of Title VII and extended the protection to pregnant employees as far as discrimination based on that particular trait. The courts have been fairly consistent in that they are ruling regarding issues related to pregnancy.
Sexual harassment is prohibited by Title VII and Title IX. Sexual harassment was not included in Title VII of the Civil Rights Act of 1964 until 1980. Its primary intent is to protect employees from harassment in their work environments. Harassment is considered to be a form of sex discrimination. It can manifest itself in many forms, from verbal statements, gestures, or overt behavior. The victim, as well as the harasser, may be a male or a female, not necessarily of the opposite sex. And then more serious levels may involve sexual coercion or unwanted physical relations. This type of behavior, quid pro quo, which just means an agreement where both parties receive some sort of service or exchange, is commonly associated with superior subordinate relationships in which the victim, for fear of reprisal, will unwillingly participate in the act. So that's all we got for chapter 9. Anything you'd like to add before we're done, Jessica?
No, I don't think so.
All right. All right. Until next time then.
All right, bye.
Bye.